Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos we are discussing the CSPA, or the Child Citizenship Protection Act, and when it applies. One of the categories that you would need to look at is whether or not the CSPA applies to immediate relative children. Now, generally speaking, an immediate relative child, just in immigration law, would be defined as a son or daughter under 21 years old and single of a United States citizen, whether the U.S. citizen was born in the United States or whether the U.S. citizen was naturalized, or whether a lawful permanent resident becomes a U.S. citizen before the child turns 21. So that is what we were talking about in regards to an immediate relative child. Now, the date to determine whether a person remains an immediate relative child is the child's age on the date the immediate relative petition was filed. So basically, there are two different dates here that you need to be concerned with. One is the date of the child under the CSPA, and another is the date of the child as to when that particular child is in reality. So a child could be, 15 years old under the CSPA and be 35 years old under the real birthday of this particular child. Now, an unmarried child who turns 21 while the petition is pending would not be placed in the first preference category, or FB1, upon turning 21, but would remain an immediate relative as long as the child does not marry. So theoretically, somebody could be 50 years old and still, for immigration purposes, under the CSPA, be 21 or below. So make sure you get the age correct when doing the CSPA, and you can file the petition as though that person were actually under 21. Okay, more on the coming videos.